Hi, everybody. This is Jack Milligan with you again from the Plaintiff's MSA and Lien Solution, a member of the SPI group of companies. The Plaintiff's MSA and Lien Solution has as its mission enabling trial attorneys to help their clients minimize future Medicare obligations and even avoid those obligations through the avoidance of an MSA. Today's video is entitled Using Judo when the defense is pushing a liability MSA. So Judo was invented in the 1800s by an individual named Kano Jigoro. I hope I've got that right. Those of you who are into Judo can send me an email and give me the correct pronunciation if I've missed it. But anyway, Kano had an underlying premise in Judo, and in short, it was that resisting a more powerful opponent will result in your defeat, while adjusting to and evading your opponent's attack will cause him to lose his balance, his power will be reduced, and you will defeat him. And this applies whatever the relative issues of power, thus making it possible for weaker opponents to beat significantly stronger ones. So that's the concept behind Judo. And in our context, what I'm going to suggest to you is that there may be an application here when it comes to dealing with defendants and claim adjusters in liability cases that are pushing unnecessary MSAs on you and your client. It's our mission to help you avoid these if at all possible, and good news, 2/3 of the time we're able to do that. For the 1/3 of the time when we aren't able to help people, claimants and plaintiffs avoid an MSA, and they then want to voluntarily fund one, to avoid any problems with Medicare, we offer all those regular services: MSA allocation studies to identify the amount of the problem, administration, professional administration services after these accounts are set up. But for today's topic, using Judo to avoid pushy defendants and adjusters, here's the situation. We continue to get phone calls from trial lawyers who state that the defense is ratcheting up pressure in their case, telling the plaintiff attorney that their client, your client, is going to have to do something about future Medicare. We think they must need an MSA. You certainly can't make a claim for all of these future medicals and then deny that your client doesn't need an MSA. So here's the Judo. That's the opponent's thrust and parry at you. The way to take that and use that against them is to have your talking points ready to go. And I've got those for you. There's 3 simple talking points. Number 1, MSAs are still not legally required. They are voluntary. And the creation of an MSA is a voluntary act by a plaintiff who wishes to set aside money to pay some portion of future Medicare bills. That's it. It's voluntary, which means no one has to do this. It's, as I've lectured before, plaintiffs have lots of options on how to fulfill their obligation to prevent the Medicare Trust Fund from being a first payer when the plaintiff has received monies that approximate future medical damages. In other words, compensation for future medical. But there are ways to avoid this. And we're so proud of our avoidance mechanisms that we sell that strategy as a package. But here's your second talking point. What you want to say to the adjuster or the defense attorney is, my client is aware of the responsibility to protect the Medicare Trust Fund. We're aware of it. And we know that Medicare has said that this is a plaintiff issue. It's our issue and we're dealing with it. So my client, here's number 3, here's your third talking point. My client is consulting with both medical and legal experts regarding their liability, if any, for future Medicare bills, and will be taking their advice. We will, of course, hold your client harmless, et cetera, et cetera. So those are your 3 talking points. How to use Judo against defendants and adjusters that are pushing unnecessary or even perhaps potentially overfunded MSAs. A couple last comments. 2 things. It's August 25th. As I'm recording this, we still do not have the guidance that we've been expecting for, let's face it, we're now in 8 years. This goes back to 2012 when guidance was first promised in liability MSAs. Par for the course. Not unlike Lucy in the Peanuts comic strip, holding the football for Charlie Brown to kick and then pulling it out. It seems like we're going through this with every announcement of a further delay in the issuance of this guidance. Along the way, a little bit of advice, maybe a suggestion. The best way to handle these issues is to warn your client in advance. That is disclosure. And we know that as part of your disclosure to your client, you're also concerned about making sure that your client understands that Medicare law and Medicare issues in dealing with Medicare and Medicare liens and all types of liens are outside of the scope of your representation. And so we have created a trial lawyer protection packet to enable trial lawyers across the country to be able to have these conversations with a minimum of time expended with their clients, and in writing to get their clients up to speed on what the issues are with Medicare law, very simply and in layman's terms, and then get their client's signature as to the directions that the client wants you to take in terms of hiring additional experts, even attorneys, to deal with these issues. So at the bottom of this email and this video, you're going to find a link that will take you to this website, our trial lawyer protection packet. Take a look at it. We've got numerous recommendations and reviews from attorneys around the country. We've included not only Medicare risks, but the need to disclose and discuss with your client dissipation risks in any potential settlement that you get them, along with the potential for tax issues. Yes, tax issues, unexpected tax issues in personal physical injury cases and missed tax savings. So there's literally 3 disclosure documents in here to enable you to cover all of these potential issues with your client and get their informed consent in advance. Click the link, take a look, and if you have any questions, give us a call. This has been Jack Milligan for the Plaintiff's MSA and Lien Solution. We'll be back at you soon. Take care.